SJC-11458, Commonwealth v. Emmanuel DaSilva.
Thank you.
Good morning.
Palmer.
May it please the court, my name is John F. Palmer. I represent the appellant, defendant, Emmanuel DaSilva. This is an appeal from a first-degree murder conviction and related charges arising out of a drive-by shooting that occurred in Roxbury in February of 2007. Initially, the defendant and the co-defendant were tried together. In 2010, the co-defendant proceeded to trial. The defendant's counsel was ill and was mistried. He was tried again separately in 2011. The facts basically are that at or about 6 o'clock on February 13th, there was a group of people standing on the street on Maywood Street in Roxbury. A car was seen fleeing from the scene. Several witnesses who were on the street at that time testified that shots were fired from the passenger side of the vehicle. Anywhere from 2 to 4 people, it was stated by various witnesses, were in the car, and a witness who was in a nearby apartment heard the shots, went to the front window, saw some individuals who had been shot lying on the street, called 911. The 911 call came in at approximately 6 minutes past 6. Police officers responded to the scene.
Do the ballistics experts, were the ballistics experts able to identify any of the bullets, if there were any, that were projectiles that were recovered from the victims' bodies? And were they able to say whether they all came from the same gun, whether some came from a revolver, some came from a semi-automatic or a 380 caliber semi-automatic? Were they able to offer any testimony along those lines?
I don't recall that testimony. In reviewing the case yesterday, after having viewed the facts over a year ago, I looked for just that point. They found a cartridge on the street on Maywood that was linked to the cartridges that were found in the co-defendant's vehicle. As far as the bullet, and I may be corrected, stand corrected, I don't believe that any of the bullets were matched with the cartridges. So, in any event, the police responded approximately 6:16. Some of the police officers who responded, and then they put out a description of this vehicle with 2 people or 4 people or 3 people in the car. At about 6:16, the police who were responding to the scene observed a suspect vehicle, the suspect's vehicle. They pulled it over. The defendant was seated in the passenger front seat. The co-defendant was the driver. They were both ordered to exit the vehicle. They recovered 4, this was the ballistics evidence, 4 shell casings, 38 caliber shell casings from the floor area of the passenger seat, and 2 shell casings on the passenger seat. Both defendants were arrested, and the investigation proceeded. The issues, one of the main issues had to do with a significant body of evidence that was introduced concerning a prior incident and shooting that had occurred on a nearby street earlier in the day at 9 o'clock in the morning, in which it was reported that shots had been fired at a vehicle that was exiting the area of Langdon Street, 4042 Langdon Street. And, and that car was later tied to an individual named David Evans. And the theory of the prosecution was that the shooting that occurred on Maywood Street at approximately 6 or so that evening was related to the shooting that occurred on Langdon Street at 9 o'clock in the morning. Now, the evidence, and you really have to go through the details of the evidence that was introduced, but it was the defendant's contention that there was insufficient nexus to connect that Langdon Street shooting to the defendant so as to permit its admissibility.
But let's look at the nexus as I understand it, and you can correct me.
Okay.
I understand that the bullet that was inside that car that was shot at, as well as the shells found on Langdon Street, match the .380 caliber firearm found in the defendant's home, correct?
Well, not in the defendant's home. The relatives of the defendant, Gomes.
Okay, but in the home that was connected to DaSilva, wasn't DaSilva in some fashion connected to that apartment?
Claramondo also was connected to that home.
Okay, so
Not the defendant, though, not my client.
Yeah.
okay, but there was some view that it was not clear that whether he fired that shots, but somebody connected to the defendant fired that shot, so arguably based on the fact that it was found in that apartment. And is the inference, and I gather that this was a car that was viewed as arguably a car that was viewed as a threat, and the motive, as best as I can determine, is that at some point they said, well, now that he was shot and missed, somebody better shoot and kill Evans, because otherwise Evans is going to be shooting to kill them. And that's what I understand to be the connection, is that this was a kill or be killed theme, and they happened to shoot the person they thought to be Evans, but they shot somebody who turned out not to be, just looked like him and lived across the street. I mean, that's the nexus as I understand it.
That's the theory.
Okay, and why is that not sufficient with regard to motive?
Because the evidence didn't really support that nexus. You had the gun that was found. First of all, you had the evidence of the Langdon Street shooting was that a gun that was recovered in Gomes's, I think it was the co-defendant's father's apartment, was connected to the bullet, a projectile that was recovered from Evans's car. Of course, it wasn't Evans or anybody connected to Evans that was the victim of the homicide on Maywood Street.
But there was testimony, was there not, that he resembled the victim. The jury could have so found based on the evidence presented, and was standing next to a car connected to that same Evans who turned in the car, presumably based on the evidence. Once it was shot at, got a different one with New Hampshire plates. It was on that Maywood Street, and that same car had been circling around, people staring at the group. We'll call them the Gomez DaSilvas. So there is that connection.
There are bits and pieces. You're adding
There are
little
bits and pieces.
You're adding facts that weren't there. The staring them down.
Oh, I didn't say staring down. I said they were looking, and that was from the grand jury testimony of the Mr. DaSilva. I can't remember his name exactly. He said they look funny. They look at me, and I think he was saying pointing fingers. It's just what I recall of.
We'll get into the grand jury testimony.
That what you're trying to do is you don't want that. You're trying to. You're wanting us to consider only those facts that aren't dependent on the grand jury testimony? Is that?
Well, I don't think
Does
the
it
grand
change if
jury
we disagree?
testimony was properly admitted either. But if you focus on that comment in the grand
Right.
jury, it's completely ambiguous as to what he's referring to. It certainly, he says, they looked funny at me. How that, you know, it does not provide, I mean, the point is, it does not provide a sufficient nexus to show that this defendant was somehow involved, or even the co-defendant, Gomes, was
Well, there's-
somehow involved in the shooting on Langdon Street earlier that morning.
Well, not involved in the shooting, but was aware of the shooting and was agitated by the shooting, learned about the shooting. I think there was another person involved, AJ. I'm not sure exactly the connection of AJ, whether that is the son, Anthony, or not, or some other person with the red clothing that was seen on that individual who ran into the house. And then by some testimony, contradicted, I understand, but by some testimony, the defendant comes in and at that point.
I'm not sure what testimony, the
I'm
AJ.
not sure now
The
either.
AJ testimony, frankly, was not really explained in the testimony. It may have been explained in the grand jury testimony that was never admitted because the judge excised, but that reference to AJ was never explained at trial.
Right.
Because the judge excluded it. So, you know, you have these bits and pieces, they don't add up to sufficient nexus to show that this defendant and the co-defendant or the co-defendant had a sufficient connection with the events on Langdon Street to provide a motive or any reason.
Wasn't there
to be-
evidence that the defendant was there that morning? Came in? No?
No. The co-defendant came in that morning. The co-defendant came after the police had responded on Langdon Street.
Right.
They interviewed Claire Mundo, they interviewed the father, Gomes's father. During that interview, the co-defendant Gomes came in, and he was upset and was told to leave, essentially. He left, and that's when he was observed driving away in the white Impala.
I thought there was evidence that at some point that day, while Claramundo and his family were sitting in the van for reasons that are odd to understand, that the defendant, not the co-defendant, the defendant, came by to visit.
I'm sorry, I didn't.
That the defendant, not the co-defendant, came by to visit his Claramundo and his family. I thought there was evidence to that
I
effect.
thought he was with Claramundo when the other car came by. At
And
that
didn't he
point.
go to get his daughter at school?
Yes.
Didn't he
okay.
accompany him?
What-
So it's not like he had no connection.
And then that other car came by when he was there with Claramundo. The one where you say it's ambiguous about whether they looked funny. That looked funny. People
Well, they
looked funny
had,
from that car.
the evidence, you're correct, Judge, that the evidence came in at trial that Claramundo came by and saw, the defendant, my client, DaSilva came by, saw Claramundo, and then accompanied him to a school where he dropped his daughter off at school. And
Right.
so
So
it
it's
was
not
that
like
period of time.
So it's not like there was no connection with the events earlier in the day.
Well, that particular, that was not connected to the events earlier in the day. That was sometime around 1 or 2 o'clock in the afternoon. The shooting occurred at 2 o'clock, at 9 o'clock in the morning.
That depends, I suppose, on what you mean by events.
Well, well, that's true. I mean, it was not part and parcel of the shooting. It had to do with taking the daughter to school. That's what the testimony was.
There wasn't evidence that the defendant and Claramundo discussed that the people in the car were the people that shot at AJ, whoever that is?
Well, the testimony on that, again, that was grand jury testimony that was admitted.
Good. Okay.
My argument is in error, but even accepting that testimony, it's referring to they. It's not the defendant talking. It's sort of this vague, rambling discussion by Claramundo and the grand jury, and So it does not attribute that knowledge to my client. But I will say that it takes a very close reading of the transcript to go through some of these facts to determine just what was admitted, what wasn't admitted, what was a grand jury testimony that wasn't admitted, because when the government made its proffer early on, they were including in their proffer to persuade the trial judge that this was admissible, they were including some conversations that never got in to evidence. Mm-hmm. And some of them had to do with what you're talking about, whether or not the defendant knew or referenced what had happened earlier and that type of thing. So, so by the time he, and the defendant was continuously objecting to this kind of evidence coming in. He did, I will say, he recognized some prejudice. He excluded 3 of the guns, or 2 of the guns that were recovered from Langdon Street, but he allowed 1 gun to come in. Now that gun had no connection at all to the homicide on Maywood Street, but it did have a connection to the shell casings that were found on Langdon Street.
Do you plan, I hope you do, to return to your argument about grand jury and that there was an impermissible amount of grand jury testimony included because it wasn't directly contradictory to the testimony at trial?
Right. This was Claire Mundo's testimony. Absolutely critical witness, provides the nexus, if there is a nexus, attempted nexus between the 2 events. Also tries to implicate my client in a retaliatory motive. I think at one point during the examination of this witness, the defense lawyer in frustration said, "There's something fundamentally wrong about convicting a man based upon grand jury testimony where there's no cross-examination and there's no opportunity for the jury to observe his demeanor." And that's essentially what happened in this case. And in this, you're all familiar with Commonwealth versus Day and its refinements. The first requirement, obviously, is that it essentially adopted it did adopt proposed Rule 801D 1A, or whatever the provision is that deals with the admissibility of inconsistent statements. It allows for statements to be introduced if they're inconsistent, introduced as substantive evidence if they're inconsistent, if they're made under oath, and then if they're not the product of coercion, and not or, and in the declarant's own words. So in this case, first of all, in Commonwealth versus Day, and I know the Commonwealth has said in its reply, in its brief, that it's not necessary to have a voir dire. There was no voir dire. The judge did not have a voir dire, despite the defense counsel's asking for it repeatedly, because this witness was all over the lot in terms of what he was testifying to or not testifying to. It was a quintessential case for a voir dire. So
if there had been a voir dire, what would the judge have learned that the judge did not already know? The judge had read, I gather, the entire grand jury testimony. I think he said that, correct?
He did say that.
And he listened to a good deal of the testimony of Mr. DaSilva, who was clearly reluctant to be testifying against his nephew. Claremondo DaSilva was testifying against his nephew.
Right.
So what would have been accomplished at a voir dire which the judge could not have understood from his review of the transcript and his reading of and his listening to the testimony?
Well, I think that the determination of whether or not there's coercion is should be a broader consideration than just looking at the grand jury minutes. That's what he said he based his decision on. At the early even before Clermondo took the stand, both the Commonwealth and the defense alerted the judge to the fact that this witness, there may be problems. So the prosecution knew that it might be a problem. Day imposes upon the prosecution or any proponent of prior inconsistent statements the obligation to seek a voir dire. That's the obligation of the prosecution under Day. Now, the two cases that were cited by the Commonwealth, the judge made the decision after he had heard all of the direct examination, all of the cross-examination, and then in a technique that another way to impeach impeach or introduce the evidence, they simply read the grand jury testimony after the judge made the ruling that it was permissible to do so. In this case, the judge, there was some evidence. There was evidence that introduced on cross-examination that this witness had been coerced in ways that weren't apparent from the grand jury testimony. There are ways in which this witness indicated on cross-examination that he may have been susceptible, that it wasn't the testimony was not voluntary in a true sense because of his prior mental condition. There's a whole area here of voluntariness that wasn't explored because the judge simply prejudged the question of coercion based upon reading the grand jury minutes. And that's error, I think.
Okay, thank you.
Thank you. Am I through with my time? Then
More than through with your time, actually.
Then I'll rest the remaining points on my brief. There are a couple, well, you don't allow rebuttal, do you?
We don't.
Okay. Thank you.
Not today.
Good morning, Your Honors. May it please the Court. Dara Kesselheim on behalf of the Commonwealth, and with me is Mark Zanini and ADA Julie Higgins, the trial prosecutors on the case. I'd also like to acknowledge the presence of the victim, Fausto Sanchez's parents, in the courtroom today. I'll begin, if I will, with the Court's permission, with the evidence of motive and the Langdon Street evidence that the defendant contests. In this case, the defendant's connection to the Langdon Street shooting is much stronger than was presented by my brother. By his own admissions, the defendant on the night of his arrest gave a statement to the police, and that statement was read into the record by the detective who, one of the detectives who conducted the interview. And by his own admission, the defendant's aunt called him that day and told him of the events of the morning at Langdon Street. He went to the scene to see what was happening. He left after a few minutes, but he returned later that day, and he remained at that scene for hours that day. And the question is, why is this relevant? Why was that evidence of the Langdon Street shooting properly admitted? And it was properly admitted to show motive for the killing of Fausto Sanchez later that evening. The facts...
Can I understand this? The shooting at Langdon Street,
yes.
Who was shooting at who?
It was a member of, it was someone living in 40 to 42 Langdon Street shooting at David Evans.
Okay.
And it was David Evans's car?
It was David Evans's car. The black car seen fleeing the scene was matched to David Evans.
Okay, so somebody's shooting at David Evans.
That's correct.
From 42 Langdon.
That's correct.
Okay. And how does that make motive for a later attempt to shoot someone who looked like David Evans?
Because the motive for the later shooting, if I may back up just a little bit with the facts, the night of the murder, the victim is standing out on the street with some of his friends, standing on the sidewalk with some of his friends hanging out. A car drives by, opens fire, and the victim is killed. The car is described by an eyewitness And the defendant and his uncle are stopped within minutes in a car matching the description of the car given by the eyewitness. And the defendant, and there are ballistics evidence recovered from that car. There are also
No guns, but
no
shells.
guns. No guns are recovered from that shooting. There are 6 shells recovered from the car. There are 2 that the defendant is sitting on, and there are 4 in the well of the car, the passenger side, so the foot area of the passenger's side of the car. There is also a shell recovered from Maywood Street, and that shell is ballistically linked to the shells recovered in the car. So all of those shots came from the same gun.
Okay.
Again, the defendant is sitting on 2 of those shells. So why was Fausto Sanchez killed that night? Fausto Sanchez was killed.
Can I just interrupt you for a second? Was there any ballistics matching of the shells in the car to any projectile found in any of the victims?
No, there were 2.
Not even by type of weapon?
No, there were 2 bullets recovered from the Maywood Street shooting. There was one recovered from one of the victims' jackets, and there was another recovered from a nearby house. Those were matched to the same source, and it was a 38 caliber revolver, but they were not matched to the shells in the car.
The shells in the car had been, okay.
So there were 2 guns at least involved in this shooting, neither of which was recovered.
How do we know there were 2 guns?
Because there is a projectile recovered from one of the victims. There's a bullet recovered from one of the victims' jackets.
That was fired from a revolver.
Fired from a revolver. It was fired from, one was a 38 caliber revolver and one was a 380 caliber handgun.
Because they weren't matched to the same source. You said
There-
they were
there
matched
were-
to the same source.
So there are 2 bullets matched to one source.
Yeah.
And 7 bullets matched to a separate source,
7
but
bullets?
also, sorry, 7 casings matched to
But
a
6
second
of those casings were in the car.
Correct,
1 was on the street.
correct,
So 6 casings matching the one on the street
correct.
doesn't mean there was a bullet fired from that gun, does it? Just means there was a casing on
A
the
casing,
street.
the inference is that there was a bullet fired from the gun which left the casing.
Okay.
And then there was a second weapon.
Yeah, let's go. Was there testimony that there were 2 guns? I mean, did any of the witnesses see 2 shooters, 2
Yes,
guns?
there was a testimony as to multiple shooters
Okay.
from the passenger side of the vehicle.
All right.
So back to the question of how do we get motive from this? And the reason that Fausto Sanchez was killed that night is because he looked like David Evans. He was standing next to a car matched to David Evans, and he was standing directly across the street from David Evans' house. So what's the motive to kill David Evans? And the motive to kill David Evans was hostility relating to an ongoing feud between the DaSilva Gomes family and David Evans. There's retaliation for an earlier shooting involving AJ, and there's not much evidence as to who AJ is, but we know that the defendant identified David Evans as the people who shot AJ, and there is fear. There is fear of retaliation by David Evans for that earlier shooting on Langdon Street. David Evans was involved in that earlier shooting in a black car. He turns in that black car, he gets a new rental car, and that rental car is seen circling Langdon Street that day. So there is, as I believe Justice Gantz put, a kill or be killed motive. And that is part of the motive established by the Langdon Street evidence. It was not only appropriately admitted, but it was necessary. It was necessary to show, for the prosecutor to give a complete picture of what had happened that day. And it was under the Bradshaw line of cases, and then it was necessary to show the motive for the killing of the victim.
Doesn't the earlier incident have more to do with the co-defendant than with the defendant?
No, I think it relates as to both defendants, and it's also a joint venture.
The defendant wasn't really on the scene of the earlier shooting.
He was at the scene of the earlier shooting. So by his own,
But wait a second, like, we were talking about that before. When did the defendant show up at the scene of the earlier shooting? The afternoon?
no, he shows up twice. He shows up in response. He gets a call from his aunt early in the day.
How early? Close to the shooting?
He says that his aunt calls him and tells him that she'd seen on the news evidence of this police activity at the house, and that in response to that, he goes to see what has happened.
Okay.
Um,
So
That's
but he's not
post-shooting.
there around the time of the shooting itself.
There's no evidence that he is there at 9 o'clock in the morning, if that's Your Honor's question. But there is evidence that he's there, and he goes to check out the situation, and he leaves, and then he comes back, and that in total he's there for several hours that day.
Okay.
Let me ask you, the spent cartridge that was found in the street and matched to the spent cartridges that were found inside the car.
Yes,
Earlier in the day, the police had collected spent shells in that same area? On the street? Oh, no, it's a different street.
Different
a
street.
Different street.
different street. Those bullets,
So it's only, how do you know that, that the spent shell that was found in, what was it, Mayberry Street?
Maywood Street,
Yeah. How do you know that that was fired at 9 o'clock that night?
at 6 o'clock that night?
6 o'clock that night?
It's an inference, Your Honor. So
Okay, all right.
So there is a shooting involving multiple shots. The call comes in the first call related to the shooting comes in at 6 p.m., 6:06 p.m., I apologize, 6:06 p.m. And within 10 minutes, again, it's multiple shots fired. Within 10 minutes, the car seen fleeing the scene of that shooting was described as a newer model Chevy Impala. And within 10 minutes, a newer model light-colored Chevy Impala is stopped with the co-defendant driving, the defendant sitting in the seat, sitting on casings that are matched, ballistically matched to the casing found at the scene just a few blocks away.
And there had been testimony that there were more than two people in that white Chevrolet or that silver Chevrolet earlier. So the inference was, I suppose, that whoever else was in that car took off during that 10-minute period of time between the shooting and the stopping of the car, took off with the two guns, and nobody knows who that is or where the guns are.
That's correct.
Okay.
That's correct. I think it's also important to note the care with which the judge considered the propriety of the admission of that evidence and the way that evidence was tailored. His decision to admit that evidence is reviewed under an abuse of discretion standard. And that standard is that no conscientious judge acting intelligently could honestly have taken the view expressed by him. That is a high standard, and this is a case in which the judge carefully considered what evidence from Langdon Street would come in. He tailored the evidence. There was additional evidence from the Langdon Street shooting that arguably might have come in, but he tailored it as unduly prejudicial. And then he gave a careful limiting instruction to the jury regarding the permissible use of that evidence to establish motive or intent, and stated specifically that it couldn't be used to draw inferences regarding the defendant's character or his propensity to commit a crime. So given the care with which that evidence was admitted and the limiting instruction given, the admission was proper. As to the grand jury testimony that came in from Claramundo DaSilva, this was another instance in which the judge handled the decision to admit that evidence with the utmost care. There was indication from the prosecutor early on in the case, before that witness testified, that he was likely to to be a difficult witness for the prosecution. And the judge indicated, he said something like, my guess is you're going to want to use his grand jury testimony substantively. I direct the court's attention to the record at the transcript at volume 6, pages 95 and 96 for that discussion.
Was there evidence that Claramundo had been coerced outside, other than the grand jury testimony itself? Was there other evidence introduced that Claramundo had been coerced into giving the grand jury testimony?
Apart from his own self-serving statements, which the judge did not have to credit, no, there was not. And that is another thing that was the subject of extensive examination at trial. So the prosecutor cross-examined him as to any purported coercion, and then the defense attorney was also questioned him on any purported coercion. And as was stated earlier, it was the judge's view that he did not want to cooperate with the government against his nephew, but that he was not in any way coerced to give testimony in any particular way or to say anything specific. Indeed, during the cross-examination by the Commonwealth on any purported coercion, he said his reasons for not wanting, when asked to explain his reason for not wanting to testify, he said, "I don't want all my families to blame me for the court." It is clear that his issue is not wanting to cooperate against his nephew, who's sitting at the defendant's table and whose father was in court for much of the trial, not that he was coerced to testify a certain way. And again, this is an area in which the judge made extremely careful, extremely detailed findings regarding any coercion. And he specifically, indeed, he makes findings that the defendant wasn't coerced the first day of the I apologize, the witness wasn't coerced on the first day of the witness's testimony. And then there's a break in the testimony for the evening break, and the judge comes back the next morning and says, I want to make clear my findings regarding coercion. What I find is that the grand jury testimony, which I read a few nights ago, is in the witness's own words, not the prosecutor's. There are a number of self-serving statements by Claramundo that he was forced to testify and that it was against his will. These comments, I find, are indicative of his desire not to cooperate with the government against his nephew. It is not a situation where he was coerced to testify in a certain fashion by any stretch, and the findings go on beyond that.
Are those findings based on the grand jury transcript, or are those findings based on Claramundo's testimony at trial?
I think they're based on both. I think they're based on, he does make findings related to the grand jury testimony. He says there was actually almost a complete lack of leading questions by the prosecutor, but he also finds that that he testified in the grand jury similarly to how he testified at trial, which is in an uncooperative way. And for those findings, I would direct the court's attention to the record at volume 7, pages 150.
But what does that mean that he testified in an uncooperative way vis-a-vis having been coerced to be there in the first place?
Having been coerced.
Somebody who testifies in an uncooperative way may also just be indicating they don't want to be there, and they feel like they're only there because they've been made to be there.
Correct.
But why isn't that consistent with coercion rather than lack of coercion?
I'm not sure I understand the question.
If somebody is not cooperating because they're only there because they're under duress to be there, one would expect that they wouldn't cooperate.
In terms of subpoena power? In terms of...
Well, didn't he also say he was threatened by the police?
He made self-serving statements, yes, that he was threatened. But then when pressed on those during cross-examination by the prosecutor, he says that he says that the reason that he doesn't want to be there is that he doesn't want to testify against his family, and he doesn't want his family to blame him for what's going on in court. That's when he's pressed on that at trial. And it is true that he was, while it's true that he was required to appear at the grand jury, as any witness who receives a grand jury summons would be required to appear. The standard under Day is whether the witness was allowed to give the testimony at the grand jury in his or her own words and allowed to tell their story. And in this case, Mr. DaSilva was certainly allowed to tell his own story. On cross-examination regarding coercion, the prosecutor read him several simple questions. Who is Yo-Yo? Were you there? And then says to him, and look, your answer goes on for 42 lines. Your answer goes on for a page and a half. So he was clearly not coerced to give any specific answer. He was allowed to, he was, as any witness would be, compelled to appear before the grand jury, but he was not compelled to testify in any way, and that is what is required under Day. Unless there are further questions, the Commonwealth is
Can
content to
I
rest
ask you
on
just a question out of curiosity? When I was reading this, I didn't understand, I mean, is there any explanation for why Claramundo and his family were made to leave their home? They took flight after hearing the gunshots in the earlier incident, and then the police came and they were made to sit in a van all day outside of the house? I didn't get that. Because
the reason is that the shooter, the person who shot at David Evans's car ran into 40 or 42 Langdon Street. So initially there was a sweep of the house.
Looking for the shooter.
Looking for the shooter, yes, Your Honor. And then the house was frozen and a search warrant was obtained, and there was this additional search of the house, which recovered the gun that was tied to the Langdon Street shooting, as well as personal papers of the co-defendant and other items.
Okay, thank you.
Thank you.
Thank you very much.